you have a copy of the minutes? Any additions or corrections?
Motion for approval.
Second.
Any questions? All in favor? Okay, it is unanimous. You have a copy of the transfers. Any questions on those? If not, I entertain a motion they be approved.
Motion for approval of the transfers.
Second.
Did you get those? All in favor? Okay, it is unanimous. Also, the bills and hand checks that we've got listed. Any questions on those? If not, entertain a motion they be approved. Died for lack of second.
Motion approved.
All in favor?
You're going to recuse from any Parks and Rec that may be on there,
Get
please?
that? We need to put in the minutes that the clerk fees were turned in, $86,200.84. Property tax, $1,811,771.80. That needs to be in the minutes. Also, that Tom Prather completed his training union and should have received his check.
With time to spare.
We had 2 weeks to go.
2 weeks to go.
I'll ask Glenn to bring us up to date on the ongoing library appointment.
As the court knows, we were awaiting an opinion from the Office of the Attorney General. Mr. Mills, thank you for bringing that by my office yesterday. I did not get a chance to read it until last night and read over it a couple of times. It spends most of the time describing what is required for open meetings and what's required for the call for a special meeting, and whether there were things that were done on the agenda that were not advertised or not publicized as I think they're required. It does not go to the definitive question that we have as a court. Today, what I'd like to do is just tell the court that I've not had time to, number one, digest the entire opinion, plus what the AG's office has placed in here. Kind of interesting, there was a side note on the bottom of page 5 or 6, page 6, that draws attention to an older opinion from 1982 that we've tried to pull up this morning and cannot, that we may have to call a contact person there in the office and have them email it to us or fax it to us. But before, even after I've read this opinion overnight, I think my statement still would hold until I saw this, that I'm not sure we have a vacancy. So there may not be anything required of the court. But I would like the opportunity prior to our last meeting of the year to get a copy of this OAG 82.222. The only reason I want to see that is because it brings into question as to whether there is another avenue that a resignation has occurred. So long and short of it is, I've just had this courtesy of Mr. Mills, and I've read it last night. We were in court off and on all day yesterday. But it brings up this older opinion that we cannot pull up for some particular reason in Westlaw. So I'd like the additional time to look at that.
Is there any comments or anybody?
Mr. Mills is here.
Mr. Mills,
Mr. Langford, too.
you heard, Mr. Langford, you heard the comments, didn't you?
I didn't hear all of it, Judge, but as I understand it, he wants longer to look at it.
Yeah.
Yes.
Because of an Attorney General's opinion.
Yes, yes. Nor have we had a chance to meet on it.
Okay.
At the library.
Okay, thank you.
So a little bit more time and we'll be back.
Okay.
Okay.
Mr. Mills, thank you for bringing that by the office. I appreciate it.
We have several appointments to make. A reappointment on the airport board. Bill Taylor is eligible to serve another term and would recommend that he be reappointed.
So moved.
Is there a second?
Second.
All in favor? Okay, it is unanimous. And then on Parks and Rec,
Excuse me, Judge. I'm going to recuse myself from this one. And if it wouldn't be too much
Not
trouble,
trouble.
if we could do number 16 at the same time,
Okay.
I won't have to step out twice.
All right, go on.
Thank you, sir.
15. I have talked to the mayor and, about the joint appointment, Eric Flegg, I believe is the way you pronounce that. And they came recommended from Parks and Rec Board, but also several people. And we had a lot of good names that we went through, but we agreed that this was the one we would recommend. So that comes from the county side. I don't know if the city's voted on it. Did they vote on it? We don't have to accept it, but that'd be my recommendation. So if you agree, I'll entertain a motion.
Make motion.
Mr. Levinson, Mr. Prather, any questions? All in favor? Okay, that is unanimous, and we'll skip down to number 16, Jerry.
Just, I guess, the formality, Monday night, I went before the city council and they had approved it, but I'm coming before you to ask for you guys to do a final approval for the pickup truck and the used passenger van that were listed outline itemed within our capital budget. Both of those items came in under budget. We budgeted $30,000 for the truck, and it came in, it's a 2015 model, and it came in at $29,329. And then the van, we budgeted $25,000, and it came in at $23,587. And it is a used van, 2014, and it's got approximately 20,000 miles on it.
We have, that's in the budget. I think we've even already given you the money, so
Yes.
I don't think, Glenn, you correct me, she even needs to bring it before the court. I'm pleased that you have,
would
but
be-
it's been budgeted and the money's been sent, but anyway, is that necessary?
We can just do a cursory vote.
Yeah.
That's
But
fine.
I guess a motion to approve that is
Motion for approval.
Alvin second. All in favor?
One other thing, Judge,
You
in
may.
the paperwork that I had sent to Stacy in the email, there was also the reappointment of Tom Willett.
Yeah. Is
Which
that
I
on there?
didn't see on the agenda, unless I just overlooked it.
I guess we overlooked it, yep. I think we did that last week. I think we did.
Did we do it at
We
the
did,
last
yeah.
one?
I've got last.
Oh, okay,
I've
my
got
bad
last.
then,
Yeah, I
okay.
was gonna say, I
Okay,
remembered that.
perfect, all right, perfect, thank you.
Thank you. Think we'll let him in?
No.
All right. Number 10, these are more appointments. A lot of these appointments ran out December 31st, reason we've got so many. These two are reappointments for the Tourism Board. Colleen London and Phyllis Kroom are two reappointments. And Roy Cornett is a new appointment. We can take them all three at once or one at a time. What's your pleasure?
Motion to accept all three.
Okay. Is there a second?
Second.
Any questions? All in favor?
Judge, I'm gonna abstain from that, because it's my understanding, and just be consistent with what I've done over the years, that the court has no authority to approve that. That's strictly the mayor and the judge. On that,
We don't, yeah, we can do it without that, without your approval, but I've
Right.
always brought them before the
right,
court.
right.
Yeah. Do you vote for it?
I abstain.
Oh, okay. Okay. Ordinance 1406, first reading, that's where, about the vacation.
This is an amendment to your existing administrative code. It's adopted ordinance number 12-02. It was adopted April 26, 2012. There has been one further amendment back in November of 2013. Whereas the County of Scott, by and through the fiscal court, has previously adopted a new administrative code on April 26, 2012. Whereas said code was amended on November 25, 2013, and whereas the current administrative code, as amended, now requires additional language to clarify employee vacation time. Now therefore be it ordained by the fiscal court of Scott County, Kentucky, that ordinance number 12-02, as amended, shall be and is hereby amended to include the following provisions. Subsection, or section 3.7, subsection B, vacation annual leave. All employees occupying an established position shall receive vacation as follows. During the first 10 years of continuous employment, employees who work 35 hours per week shall be allowed 70 hours vacation per year. Employees who work 40 hours per week shall be allowed 80 hours vacation leave per year. Employees assigned to 24-hour shifts shall be allowed 144 hours vacation leave per year. Beginning with the 11th year of continuous employment and annually thereafter, employees who work 35 hours per week shall be allowed 105 hours vacation leave per year. Employees who work 40 hours per week shall be allowed 120 hours vacation leave per year, and employees assigned to 24-hour shifts shall be allowed 216 hours vacation leave per year. Number 2, no other changes to the remainder of section 3.7 subsection B, vacation annual leave. If any provision of the amendment to the administrative code is held invalid or unconstitutional by any court of competent jurisdiction, such decision shall not affect the validity of other provision, or any other provision thereof, This amended ordinance shall become effective upon passage and publication according to law. I've arbitrarily dated that the 23rd in case it is approved next meeting.
And this just goes back 2008 when we had the recession. We changed that, and it goes back to what it was for the past some years or 30 years, and gives everybody 2 weeks. So that's first reading. We need a motion to approve first reading. Bill? Tom? Any questions? All in favor? Okay, that's unanimous. And then we've got second reading of the ethics ordinance.
I'll do this by summary of the court, please. An amendment to an ordinance relating to the establishment of a code of ethics for elected and appointed county official employees or candidates for public office in Scott County, Kentucky. This is ordinance number 14-05. Whereas the Scott County Fiscal Court has the authority pursuant to KRS Chapter 65 to enact an ordinance establishing a code of ethics to guide the conduct of elected and appointed officers and employees of Scott County. And whereas public office and employment are a public trust, and government has both duty to provide their citizens with standards by which they may determine whether public duties are being faithfully performed, and to apprise their officers and employees of the behavior which is expected of them while conducting their public duties. And whereas it is the purpose of this ordinance to provide a method of assuring that standards of ethical conduct for local government officers and employees shall be clear, consistent, and uniform in their application, and to provide local officers and employees with advice and information concerning possible conflicts of interest which might arise in the conduct of their public duties. Now therefore be it ordained by the Fiscal Court of Scott County, Kentucky, and then it outlines the ethics ordinance with the changes that have been made and recommended by your Ethics Commission.
Any questions on that? You've had the chance to.
First, I want to apologize for not being here at the last meeting. Believe me, I wish I could have been here rather than dealing with what I was. But I did watch the video to try to catch up on this, and I have a number of questions on some of the issues in here. I appreciate Mr. Johnson and the Ethics Commission and the tremendous job they take on for no compensation, I might add. I really appreciate all their work. But I did have a number of questions on the updated ordinance. And when we do this, I think we need to get it right. And just a couple of those. One in particular that was discussed a little bit at the last meeting was whether or not to include the primary candidates. And all those candidates have the potential to fulfill an office. And in my opinion, if this is worth doing, which I think it is, they should be included some way. And if we can figure out some way to streamline y'all's workload to make it work, I'd be all for that. But I do think they should be included if we're going to do one of these, because they do have the potential to hold one of these seats or one of the others. And there's several other questions I would like to.
Let him address that one. Go ahead.
Sure. Yeah, Al, the intent here was the fact that this past election highlighted the fact that we do not have a procedure in place that's within the court, or in the county, I should say, county clerk's office, to properly implement this ordinance. The idea of the candidates is that as a primary, so we had a number of people that filed for candidacy, never published an ad, never put up a sign, never did anything. It really became, I guess they felt they overwhelmed in the race they were running. They never did anything. Most of the ones we got, the forms back, which is the fiscal, the financial disclosure form. A lot of those didn't come in until right before the May primary anyway. By the requirement in the ordinance, the existing ordinance, they're due July 1st. We felt that because the primary candidates still would have to have it on file by July 1st, which is prior to the general election, okay, that being a primary candidate really was, it wasn't as essential. Okay, so, don't have a problem with it. Again, this is an ordinance that we're asked to look at and rewrite. We looked at the workload that it took. Anything can be added back in. This is just,
One other suggestion I had along those lines is, there's some monetary penalties here, and on those candidates, you can chase a fine you're probably not gonna collect. Maybe a better option would be to, once the deadline passes, have those names published in the newspaper. These candidates have not filed their required papers before the election
You
day.
talk-
I mean,
before the general election,
yeah,
yes.
yeah, well,
But
I think
prior
if
to
you-
the primary election,
well,
what purpose does it serve if they lose?
well, it lets the voters know that they didn't do what they were supposed to do. I mean, that's just a thought I had. It's
Yeah, no,
something to
that-
consider.
This is your all.
and-
We're here to serve you guys, but I
And
mean,
a serious candidate, I think that would be a bigger deterrent than a monetary fine, because it's gonna be very difficult to collect that. But if they're, if they're seriously seeking an office and they know they're gonna be published for not filing their required documents ahead of the election, I would think that would be a bigger deterrent
so
for
are,
them.
so are you gonna publish it just when they don't file or when
You're
they
right,
file
correct.
late?
I would say, well, my thought was that after a certain deadline, whatever date that's set, and I couldn't find the deadline for filing on the candidates in here.
21 days after they file for their
Okay.
candidacy.
So that's another issue that I wanted to discuss somewhat. Mr.
Sure.
Hughes brought up the last meeting, make it 21 days after the filing deadline, so everybody would be, 21 days, you count down, and you go down the list, they're there or they're not. And then you could publish, these people have not filed their, and that way voters would have that information before they voted in the primary. That would be, that's the way I would like to see it go.
Sure,
Whether it's-
and it's possible to put language in there like that. It makes no difference. The problem is who's gonna track it?
Right.
And who's gonna make sure that it gets into the newspaper?
Well, and I think.
Okay, who's gonna actually put the mechanics in work? And that's what we found the problem was. The ordinance can say whatever it wants. If there's no one to sit there to do it, okay, then you really got an ordinance that doesn't have any teeth in it.
And I think to that point, whomever we get to send out the letters, to send out the notices, because your committee needs someone to do that for you, whether it's in the judge's office or in the clerk's office. That's why I think that 21 days or pick a number, if you make it where it's a 1 day a month job or 1 time a month, whereas the way it is now with the 21 days after filing, if you have 60 people file, you can have 60
Minimum
different
from
dates.
November to January.
Yeah.
Correct.
So
This is what we just had.
to make it a little easier to track, make it from the filing deadline. If it wants to be 21 days, that's fine. From that period on, that way they can go and look, and if everything's not in on the 21st of February, notices can go out.
Why do you want to make someone accountable until they're elected by the people?
Because if you're a candidate, you're putting forth your name and your reputation for that office. And the public has a right to know the same disclosures as if you're elected.
I think it falls along the same lines of filing your financial report with the state. Or if we're not gonna do it, just get rid of it entirely. Get rid of the ethics commission, get rid of the paperwork, get rid of all of that
No,
entirely if we're
I
not
believe
going to
once the
enforce it.
people have chosen, then
But
there's
it also,
accountability, but up to
John
that
T.,
time.
it gives you an opportunity if a candidate has something. Mr. Johnson said last time, there's not ever been a request, open records request for,
Nothing I'm aware of. Oh, you know,
in his 4 years.
They're here on the third, just
Right.
down the hall here.
For, but if someone does wish to make that request, it would become available to that individual or to the public.
And one other thing to remember, this past election was rather unusual. Only once every 4 years can that possibly happen, and it was much larger than usual because there were so many open seats here. I mean, it's very unusual to have that many candidates, so it made this last one, I'm sure, very difficult for you guys. I can't imagine how hard it was. But,
Well, the only way we controlled it was by putting together a spreadsheet to track it. But, just for the court's information, I can go back and show you the 3 years that I've been involved with the Ethics Commission. you know, every year, there's generally something. I think the year before last, there was an election, but every time we have an election, there are people that are not filing on time. Now, it matters not to me whether you want to publish in the newspaper or not, if you want to do 21 days from the last date of eligibility to file. That's fine. That makes it very simple from that standpoint. But the question is, what purpose will it serve? If it says, and to your all's point, well, it lets the public know that, you know, people aren't following their official duties. Well, I can assure you that there are elected officials currently in this county that do not file on time. Will this be enough to make them file on time next time? I don't know. Do you want your name out there on the paper? Well, the way to stop that is to make sure you file on time. I agree with that. Okay, I don't have a problem with that. The purpose is, my question is, what purpose does it serve? And then by July 1st, we even had some people that when we did have a non-election year, the July 1st timeframe came around, I was still trying to get forms in. Okay, do you go to, what purpose? I mean, what are you gonna do with the information? I agree, it's out there for the public. If you want the public to have it, I have no problem with that. It's easy enough to take the pen and make the changes. But there will have to be mechanisms in place to ensure that it's being followed.
How would you penalize somebody that hadn't been elected by the people?
I'm sorry?
Putting it in the newspaper? How would you penalize someone? How could you have a hearing over it?
Well, John T., first of all, if we have someone that and we have had, I think over the last 3 years, 2 people that did not file at all. And both those names were turned into the county attorney and to Judge Leslie, just for them to take, and if they were gonna do it. And the one guy was pretty much done, moved out of his area anyway, and that was a non-issue. And the second person, I guess they finally got that squared away, because I got the form. But, you know, it's up to the court to decide whether or not you're gonna penalize, if you're gonna put the monetary penalty on it. As far as the newspaper goes, this last time around, we were requested by the paper prior to the primary. And at that point in time, again, I saw no purpose in some of the ones, because some of the names that I would have been on that list were people that didn't run. I mean, their name was there, but they didn't do anything. So what purpose would that have served? I don't know.
Any further discussion?
I mean, it appears to me that we should go one of two ways. Either pull it back to just elected officials and employees that are listed here, and take candidates completely out, or we should include all candidates, not just primary winners. To me, it just, if we wanna have this information on candidates, we should have them on all the candidates from time, when they file, they're a candidate, they have a potential to hold an office. If we want this information, I think we should require it of all of them. But now, if we wanna pull back and just do it after the election, as John T. is implying?
After the primary you're talking?
No.
No,
No,
if
John
we
T.
wanna do the candidates, I strongly think that we should do all candidates from, not just.
Well, I was just, what question what you're saying.
Yes.
You're saying after the general election.
Right, if we're going, I think we should go one or two, either pull it back and have this just apply to after, elected people, or if we want to include candidates, it should include primary candidates. That's my opinion. And I had a couple of other questions about just some things about, if the requirements, it talks about the requirements for the unpaid, whether uncompensated individuals that are doing jobs for the county. I was just wondering, would that include, like, 4-H volunteers, the Extension District Board, they have tons of volunteers work out there, with the youth.
You're
And
talking about for filing?
yes, this.
I believe, in the very beginning, it's pretty clear as far as who is required and responsible for filing. Let me find it here quickly. In primary, what we're talking about is the financial disclosure statement. Okay? Now, on page 5, it says the following individuals shall be required to file a financial disclosure statement: the Scott County Judge Executive, Scott County Fiscal Court members, Scott County Attorney, Scott County Clerk, Scott County Constables, Scott County Coroner, Scott County Sheriff, Jailer, and County Surveyor. Then it goes on page 6, 2. Candidates who have filed for the office enumerated in subsection 1 above, in this section. All county and jointly appointed members of the Georgetown Scott County Joint Planning and Zoning Board, Scott County Board of Adjustments, Scott County Treasurer, and department heads. Now, that's the way the ordinance is currently written, and it specifically states that those individuals shall. It really doesn't get into saying that volunteers or people that are, you know,
I guess what raised my question on that was back in the definitions on page 2. It's, in what the definition of county government employee, it refers to those non-compensated and, but they're not required.
yeah,
In the other
that's just the
sections, so-
definition.
Okay.
And there was no changes from the original ordinance in any of that.
Any other questions or comments? We would need, if you want to amend this, we would need a motion and a second and a vote, or else we'll vote on it as is.
I'd like to make an amendment to this document that all reports, financial reports, are due on candidates 30 days from the filing deadline. Before I finish the motion, I have a question. Should the person who handles this be in the judge's office or in the clerk's office? I don't want to put a job on the clerk's office that we're not here to determine, because they don't have anyone to send out these letters for.
It goes to, the report goes to the ethics committee, so they would know who hadn't.
Okay.
Here's
But who's
who
gonna- Okay.
sends out
If
the
that-
letters.
That's what I want to know. And the clarification being that a member of the judge executive's office will send out second notices or any notices.
Let's back up.
Well, let me finish my amendment if I could. Send out any notices for the Ethics Commission, and that all candidates would be required to file a financial disclosure with the Ethics Commission. That's,
Stuart, one thing with the state report, just in addition to that, if you don't file on time, they give you like 10-day period, deadline. Because it wouldn't be a second notice. You just get a notice that you hadn't filed.
okay.
A grace period of 5 days or 10 days. Well, I mean, if you're gonna send a notice out you haven't filed,
Well, what I'm saying is, you have the 30 days to file.
yeah.
Now, if you don't want to send out a second notice, that's fine.
Well,
I
I'm
don't know.
for sending out the second notice. What I'm saying, if they haven't filed it, so they violated the ordinance. You don't want to give them a grace period, or you do want to give them a grace period.
The 30 days is their grace period. But the notice is sent out. And also to Mr. Lyons' point, I think you can chase, as Mr. Johnson said, you can chase people with this fine, but if they're not serious candidates, you're not going to collect the fine. I think for those serious candidates, putting an ad in the paper is the better way to do it.
I would.
Would you
prefer-
hesitate?
Yeah.
Okay.
Here's what I would do, or I would suggest, Stuart, is instead of putting an ad in the paper saying these people have not filed, what I would prefer to see is on our website say these people have filed as required per our
Okay.
ordinance. And I say that because there could be an issue where a candidate has an illness all of a sudden, 15 days into this 30 days, they're hospitalized for 2 or 3 weeks.
Okay.
There's a valid excuse for that not being filed on a timely basis, in my opinion, as opposed to someone who just says, I don't care about that. And if we publicize that individual's name,
Right.
find out later that there has been some type of valid excuse, then you have maybe caused an issue that they may not be able to overcome in their campaign.
Okay.
But
Well,
if you publish a list saying these people have fully complied with ethics ordinance such and such,
okay.
have a list on the website, that's accomplishing much the same thing.
Glenn, question.
Yes, sir.
If that documentation was not filled out correctly, and we did put this at 30 days, what would be the time set to get that back in? Because they have mailed it back to certain people, and I've hope so far, but it does happen.
35% of the people that filled them out
also.
last time filled them out incorrectly.
Your
We have
point
to get
to
time
my
period there also.
amendment, Tommy?
Yeah, what I was gonna say is, first of all, the county clerk's office, Amber's office, will actually be the ones that will timestamp, so to speak. What they did this past time, it doesn't mean it can't change, but they would actually send me an email saying that, this person filed on date one, November the 7th, this person filed on November the 12th, or December, and so forth. So what we're saying is that, okay, they're gonna sit down and they're gonna give everybody a packet. So somebody's gonna come in from November to December, they're gonna give them their election packet that they have. They're gonna have to sit down and confirm on January 30th, whatever day that might be, that everybody is filed and is done, that they obviously know that. And then 30 days starts from there, is what you're in?
Yes.
Applying, okay. Now granted, at that point, the forms are returned to me, okay?
Mhm.
Now, at that point in time, I would collect those forms and simply have to give that information back to Amber's office. Because I'm not gonna keep necessarily the track like I did this last time, okay?
Well-
Well, I'm just saying that.
Right.
Because I may not be here next year or the year after or whatever, you know, we need to have a process in place. So that at the point, once those are turned in, you know, I can record the date I received them, okay? So if it's January 30th and I get yours in on February the 12th, then I put down February the 12th on date stamp it, that's easy enough to do. But as far as going out and publishing it on the website or whether you publish it in the paper, you know, there has to be a period of time that come 30 days later, which is gonna be roughly February 28th or March 1st, whatever it
Mhm.
is, that I give that information over to Amber's office, and then she does whatever she has to do with it. So within this building, someone has to have a mechanism in place that says, okay, by such and such a date, we're gonna publish this on the website. Who does that? I don't know. You know, who gives that information to the newspaper? I don't know. You know, just, that would be my concern, is how you're actually going to make it happen.
Question,
Yes, sir.
if they come in 30 days when each candidate files like you're saying and whatnot, do y'all have special meetings as a board
Mhm.
to oversee all these, or would you would have to have several meetings then if they came
We
in
had
staggered?
Many. Well, the first meeting, once the dates are set, we won't have, if it's February 20 or January 30th, and the last one's supposed to be in by February 28th, we'll probably meet the first Tuesday past that date to review all of them. But that doesn't mean I can't take a list that Amber's provided me of all the candidates and can't say, these are the dates they came in. She doesn't have to have the approved copy, she would just need to know when they came in. So yes, we would meet, and then we would meet several times, we did meet several times. Yeah.
I'll withdraw the amendment and start over. How's that? Since, I would like to amend this document to state that all financial disclosure statements by all candidates need to be in within 28 days from the filing deadline. That would put it towards the end of February. That all those who have filed their financial disclosure forms will be listed on our website. And I'll leave it open if someone has something to add to it, but that's my amendment to this motion, to this document.
Are we saying there's no transparency with the way it's being done now?
No. Mr. Johnson's here simply trying to get it, a little more teeth in it and to get it clarified, I think.
So the ordinance as it stands is, there's wording that needed to be changed, but there are no teeth, there's no teeth in it whatsoever. Plus the fact that the compliance to the ordinance is haphazard at best. I mean, if you look at and you were not here last time, John, I don't know if anybody shared it with you, but I gave a form out, it has statistics on it. Only 25% of the current elected officials file on time. Okay? Now, that was current elected officials, and really all you had to do there was take the one you gave me last year, update it if anything had changed, and send it back in. That didn't happen. Okay, and then I went through a number of other statistics, and it was like, 39% of them had to go out with a second notice, 35% of them that we got were incorrect, or filled out incorrectly. So what we've tried to do is we cleaned the form up a little bit, but we've also wanted to address the ordinance to say there needs to be a mechanism in place within this county government that says this is how we're gonna implement this, or the ordinance, to Davis' part, is why have the ordinance? Okay.
Let me ask Stuart a question. Were you publishing the ones that did it, that on time? Does that take the place of the fine?
Yes.
Okay.
Yes.
that's one.
So we're
Because
gonna take.
the reason I say that is, I agree with Mr. Lyons, for those candidates or elected officials who aren't serious, or even that are serious, how do we put teeth into that fine mechanism? I mean, we'd have to, who's gonna try to collect that? Does that go to the sheriff? Does it, I mean?
Well, that's,
you know,
first of all,
I
it's
think-
up to the court.
Right.
the judge.
I think that the important thing for me is to try to, the court of public opinion will have a great influence on people getting things done on time. Those who are serious candidates, who worry about perception, and a website to this end, make it very easy for the newspaper to go to the website and see who has, and by simple deduction, you could say who hasn't. What's that?
Well,
Back up again?
Glenn said we gotta go back and punt.
Okay, all right.
But we gotta take out the fine if that's what you
Okay.
want amended. Now, we gotta find out if this is what the
So
majority of the
not-
court wants.
So we're not doing a fine, we're gonna take that out. So you're-
Well, it's too much change to, have second reading now, because.
Yeah, well, that's.
We'll have to
Isn't
have a
that right?
special meeting.
Yeah, I would rather just get it cleaned up and then bring it back for second reading.
Yeah.
After I've made the change.
Okay.
So you want to, now, we need to get a
You
vote.
vote on the amendment, yes.
Yeah, including taking the fine out. Is that,
Yes,
that part of your,
yes.
okay. And is that,
So, may I ask a question of the court?
sure,
Okay. I'm not sure I understand why take the fine out. I mean, granted, it has not been collected in the past, but the fact is now that you're saying we're just gonna publish and you're gonna let the public opinion
Right.
court, public opinion, the newspaper's got a circulation of 5,000, 6,000, 6,500 people? I'm not sure.
But my understanding that the motion was that it's gonna be listed on our website and not
Right, no,
published
I'm
in the
saying,
paper.
well, but we're using the court of public opinion here.
Okay.
On the website, how many people within the county view the website?
Very few.
Very few.
Less than the
Okay,
paper.
so,
Let's go to the
so I
court's
guess, what
website.
audience are you planning on hitting, okay, with this court of public opinion? I mean, if we got a population of newspaper circulation of 6,500, a website that's got very few hits or views, do you think the majority of the people are gonna know it?
Clerk's website also.
Okay. But,
So, I mean, that's just to me, the fine, at
Have-
least, if the court chooses to issue it, if you read the ordinance, it does give you some muscle, okay, to go after somebody, even if it's a current elected official, if they haven't done it. And basically, it's saying there's a fine in there, it's also talking about withholding pay, okay, to get the forms properly turned in. So are we talking about taking all that out?
I just don't think you're gonna collect, these fines up to $500 off, I don't think even with the documentation in this, policy, Tom, that we can collect that. I just don't see how we can do it. Have we ever done it in the past?
Stuart, I can't say that show for the past 3
Yeah,
years.
3 years.
I-
Right.
Not that I'm aware of, sir.
Okay.
And I don't disagree with you, okay?
Yeah, that's what
I mean,
Yeah.
I just, but we're sitting there saying we're gonna use this as an option to bring scrutiny on an item, and to me, I don't see that
Well, the $500 only brings scrutiny to the
to the individual.
individual.
I agree. I agree totally
Yeah.
with that. I agree.
well, if you just took the 500 out, we're not gonna collect it anyway.
Well, there are two provisions there. There's one for a criminal penalty if a financial disclosure is filed and it is fraudulent on its face and then shown to be fraudulent, that takes it into district court.
Yep.
But the civil fine, I think, is what you're talking about, Mr.
Yes.
Hughes. Yeah. And I guess the enforcement of that's gonna be the difficult thing.
Now, the only thing I can say about the $500 is it may compensate somebody within the, county that's doing the work if you collect it. If you don't collect it, whatever, but the civil fine does compensate, because somebody within either, the judge's office or in the.
But it
clerk's
would have to
office-
go back into the general fund, that money would.
Right.
A fine it seems like the presence of a fine or the potential of a financial penalty might be a pretty strong deterrent to getting somebody's attention. I wouldn't want to write a $500 check. I wouldn't be opposed to leaving the penalties in place. If we believe the public has an expectation that we have a rigid code of ethics, and that's achieved primarily through a financial disclosure. And if folks can't meet that minimum standard for the privilege of public service, then perhaps there should be some teeth in it. What we don't want to get into a situation of, Tom, is selective enforcement, because that won't stand up. We have to either apply this uniformly or not apply it. But it clearly seems that in the most egregious cases where somebody has put just wrong information intentionally on the form, or they've just said, to heck with it, I don't have to do that, and I'm not going to. There ought to be a way to get those folks' attention. And I think the public deserves a mechanism that would get those folks' attention.
Well, let's do this, Tom, and you make a good point. Take a vote on the filing deadline,
Okay, all right,
okay? Then we'll take a vote on the fine,
okay.
and then we'll get Lynn to do it, because if
I
we
would-
put them both together,
I would
we got,
amend
and this is just
strictly,
to,
to the filing deadline, 28 days, financial disclosure statements are to be into the county clerk's office.
how many support
No,
that?
the
Include
county
your
clerk's
primary, right?
Include, that
Including
is,
primary,
All
yes,
candidates.
all candidates,
the filing deadlines
filing deadline.
for,
January.
it's in January.
Right.
That's your motion.
Yes.
But
Is
the
there a
finan-
second?
But the financial disclosure.
It had nothing to do with the $25 now, we're gonna vote on that, yep.
Right.
I know.
Okay,
There's
got
a second. My
further
question-
discussion.
My question is I agree that one deadline makes more sense, so there's not 50 different potential deadlines for anybody to track. And I'm okay with the 28 days. With the state registry of election finance that we all file our finance, or our campaign finance forms, they give us a hard date, much like we're getting ready to establish, but they build into it a 5-day grace period.
I have,
So if we set it for 28 days as the deadline, but we allow a 5-day grace period,
I would,
that would be consistent
Would
with
you-
what we live.
that's
I
what
would
I
accept
was-
that with my amendment, yes,
Yeah.
yes,
5-day grace period for a good cause.
yes, for good cause.
Let me ask something.
Wait a
Well,
minute,
let me-
David had a question.
When you get to the end of the 28 days and you have a 5-day grace period, the question that becomes, how are you going to notify them that you haven't gotten it yet? You've got 5 days, but the problem is when you drop it in the mail, it's gonna be dropped in the mail on the 29th day. Well, if the 29th day is a Sunday or a Saturday, then all of a sudden you lose 2 days, and then you lose another day because they gotta turn back around and get it. So that 5-day grace period is not really giving them, does that make sense?
I thought the
It does
state
make
was
sense.
10
And what
days.
we do with
Because
the,
your back and forth communication on that might not fall in line, and then all of a sudden,
and the way the state handles that for us is we get that schedule up front when we file.
Mhm.
This is when it's due. There is a 5-day grace period.
Yeah, and this is the date.
And the only thing they do, Tom, is they send us
email.
either an email if you signed up for it, or a little postcard that says, a reminder, your report is due on X date, and the
sometimes we
grace
call you.
period expires on X day.
Okay.
Well, again, that's fine. Who's going to do that reminder? Who within this building is gonna be responsible for that?
And
Because what's gonna happen, again, the way it's currently structured, maybe that's part of this whole discussion. It's currently structured, those forms will be sent to the Ethics Commission. Now, I have no problem as being right now the primary recipient of that, of taking and logging the date on it. I got this on February the 20th, February 26th, so forth, okay? And I have no problem sending an email to Amber saying, Amber, this is when I got those. But at that point in time, who's gonna sit down and send that little postcard out, or that notice?
even though the state gives us the courtesy of that postcard, I'm not even sure that is a requirement. We're adults that have filed to run for a public office.
Exactly, which I
If-
go back
if
to, I
we-
think
if
it's
we
28
tell-
days is flat.
If
You
we
know
tell
it.
folks on the front end that you've got 28 days after X date, and we will give you 5 days if you have a circumstance, I don't even know that you need to tell them anymore.
Tom, Glenn made a good point. If you use the postmark date, so if it were a weekend, we send them out through here, it wouldn't be postmarked until, I don't know.
I think the state uses that.
That's what the
test.
state uses.
And again,
The only,
I don't know
the
how much
only
we need to
information that
babysit these people.
Stacy needs is the ones who didn't file. She doesn't need to know what date they filed on. If it's 28 days, here's the ones that haven't filed, 20 people, period.
Yes, no, as of that date.
Yeah, yeah. If they file the day that they file their thing, they put that in, or the last day, on the 28th day, who hadn't filed. That's all you need. You don't, you can stamp them in whenever you want to, but you need to notify her.
Right, well, no, that's what
Yeah.
I'm saying. On February 28th, could that be the date?
Yeah.
You know, there would be, Stacy.
Then the
or
letter
Amber would
goes
be
out
a listing
that
says-
you've got 5 days
Right.
to,
But now, again,
Grace period.
now what you're saying is, okay, well, this person didn't, so I've gotta start tracking when their 5 days is up. You know, then we send another list back saying, okay, I got the 5 days. You came within the next 3 days. I'm just saying, in order to be go, because you're going to a point where you're talking about now putting this on the website of those who
Okay.
complied and those who did not. I think, go back to Stewart's earlier, just make it flat, forget the grace period. You don't need a grace period, you got 28 days to do it. My personal opinion.
I'm not
And I'm
disagreeing with it, I'm
concerned-
trying to get it down where we can vote on it.
Well, I understand, and I'm trying to make sure I got the notes in here,
Yeah.
so when we go back to meeting, I properly understand what you're asking for.
Okay, Stewart's motion was 28 days, and had a second. We had comment on it, Tom, we can vote against it or for it. Is there any further discussion?
I only suggested 5-day grace period,
Yeah.
just a little latitude. I don't even think there needs to be an additional mailing that announces you're now in a grace period.
Okay,
So I can get comfortable with the 28 days.
okay,
I
that's,
don't think we have to hold candidates' hands. They know what the expectations are, and they ought to be able to meet them.
okay, the motion is 28 days, period, drop dead. Okay. All in favor? Okay, got that. Now, the second issue was the $25. Do we have a motion to change it? Because it's already in there.
Yeah, this was.
Is there a motion to change the $25 fine? Okay, so,
You're talking about the civil fine.
civil fine. There is not a motion? Okay, then we leave that in. Okay,
So it doesn't change.
so it's not that much of a change in it. Is
Yeah.
that,
Can I ask for just one clarification so I can write it correctly? Hopefully write it correctly. I'll put the 28 days in, no problem, from the filing deadline.
Mhm.
So it's gonna be in February at some point in
Yes.
time, each year, or each election year. Are we gonna treat that 28 days being met as of the date of the postmark, or when it's actually received?
Postmark would be consistent with the state.
That's what I've got marked here. And then in terms of the notification, not notification, but the publication, that's just gonna be a function that we'll just put it on the website. I don't
Yeah.
know if that has to be ordained.
Doesn't have to be anything.
Okay. I can make that change, get it out to you.
Okay.
now, we'll have to advertise for second reading again.
Yes.
Right, okay. We already.
Are they gonna turn back that notice with the postmark on it, so it can be monitored? Are they gonna bring that little card in with turn it in with their paperwork? Hey,
I'm talking about the
stamp on
financial
that
disclosure
Or just
paperwork.
a postmark on the envelope, I think.
I have no problem taking the envelope and sticking it to the form if that's what you wanna do.
That's probably.
I mean, how would you know if you didn't have,
You're gonna log that anyway on your spreadsheet when you receive
Well,
it, but you can use the postmark.
That's
on
what I
it.
did this past time, but what I would do is, yes, I just simply, the date I received it, which is actually the day, probably the day after, but, you know, I can use the postmark just as easy, if that's what we're gonna do.
Let's do that.
And I can just staple the envelope, unless it comes via email, and there are some candidates that send it in via email,
But you'll have a time on that email anyway, wouldn't you?
if I print it off that way with vinyl on top of the header.
Everybody comfortable with what we got? All right. Thank you, Tom.
Thanks, Stacy.
Well, we appreciate what y'all do.
Can I ask
The
one-
compensation will be doubled.
Yeah, well, that's exactly what I was gonna ask, Judge, is, you know, we have so many other boards and committees that people serve on, and this one is extremely important, and I don't understand why there's not any type of meeting stipend or anything with the time that they have to give up to be able to perform their job.
It's what?
He's using a lot of paper and ink.
Right. Well, and that's, I mean,
I don't have any problem with compensating them for meetings.
right.
I mean, let's bring it up at the next meeting and think about it.
Okay.
Mr. Lyons, that,
Yeah.
I had one more question while Tom is here. I just, sorry. On page 7, when it spells out, after the section C, it spells out elected officials, county, and jointly appointed members. Members of what? I wasn't sure what.
Tom, you correct me if I'm wrong, I think that goes back to that jointly appointed,
I'm sorry,
appointed
you're
be
on
the
page,
planning and zoning
page
commission.
7, I'm sorry, Alvin, where at?
On page 7, under section C, the number 1,
Mhm.
it said elected officials, county, and jointly appointed members. But I wasn't clear on what members of what.
Yeah, like the planning and zoning would be appointed, joint planning and zoning.
Okay, it just didn't spell that out. I thought that's what it was, but it just
Yeah, I
wasn't
think it
clear.
still goes back to
No, let's go there.
the item
Airport
on
board.
page 5, where we talk about who's required,
Parks and
and it talks about
Well, you
appointed
got-
members.
You got the library extension,
On
district
page-
boards, all
You've
those.
got,
Page 6,
Yeah.
item 3.
question, Tom, because the library and extension board and health board are all, no, I'm just asking a question,
Right, no.
are all taxing districts. So do you need, I'm asking the court.
That's up to the court, because
Yeah.
this part of the ordinance was not changed, okay?
Yeah.
So this is what was instituted or implemented back in '94.
Right.
So if there is a change and you wish to change that, I guess you would just have to bring it up in your discussion.
And I think it goes back to that, as Tom mentioned on page 6, item 3 there at the top, when it says all county and jointly appointed members of the Planning and Zoning Commission Board of Adjustment. Alvin, that's where it's defined.
Okay.
But now, if you wanted to include those other members,
No.
I'm sure you could.
Anything else, Alvin?
No, that's all.
Thank you.
That's enough.
Okay, moving on. I gotta see where I am. Resolution, on the, Revenue Commission, Andrew has been getting together the interlocal agreement ordinances, and we have always voted on them, but we haven't passed resolutions, all of them. And he suggested that we have a resolution adopting that as opposed to just a motion, am I correct?
Yeah,
So-
you have passed both the ILA and resolutions for a lot of them. Ms. Hamilton and Mr. Hartley found out we failed to do that for the Joint Revenue Commission, so that's what this is for.
The interlocal's already been signed.
Yes.
We just don't have on record. So I'll get Glenn to read that.
And I think that's probably something that's in the approval process coming from Frankfurt as well, before they're all recorded and accepted. And this is resolution number, and I better, instead of resolution on 1415, I'll flip that around for number 1415. A resolution approving an interlocal agreement between the Scott County Fiscal Court, City of Georgetown, and the Scott County School District for the operation of a joint revenue commission, and authorizing the Scott County Judge Executive to sign all relevant documents. Whereas the Scott County Fiscal Court has considered an interlocal agreement between the Scott County Fiscal Court, City of Georgetown, and the Scott County School District for the operation of a joint revenue commission. And whereas the Scott County Fiscal Court is desirous of entering into said interlocal agreement pursuant to the provisions of KRS 65.210 et sec. Now therefore be it resolved by the Scott County Fiscal Court, Section 1, that the interlocal agreement between the Scott County Fiscal Court, City of Georgetown, and Scott County School District for the operation of a joint revenue commission is hereby approved by the Scott County Fiscal Court. Section 2, that the Scott County Judge Executive is authorized to execute the interlocal agreement and any relevant documents on behalf of the Scott County Fiscal Court dated this 12th day of December. Stacy, I'll make that correction, send you.
Motion to approve.
Second, Mr. Prather. All in favor? Okay, it is unanimous. David?
Good morning. One of the things that's required for our service to operate is that we have a licensed physician that works in Kentucky. That is a state requirement, as well as when our paramedics relicense and recertify, we have to have the medical director's signature. The current medical director no longer practices in Scott County and has since moved to Berea, and we feel it's the best that we employ a physician that's local practice. I have with me today Dr. Patrick Yorba. He's been at Georgetown Community since 2003. He's board certified in emergency medicine. Received his undergraduate training at Georgetown University, and his residency in emergency medicine was at the University of Virginia. He works very closely with our crews every day at the hospital, and we feel at this point we'd like to enter agreement for the next year with Dr. Yorba. So I'd like to ask the court to approve him to come on as medical director of our service.
I might add for the doctor that I contacted Mr. Huff at the hospital, and he recommended you very highly also, so.
I appreciate that.
And,
You talked to me about that last time.
did check. One thing, a question that I have, will new hires be approved or interviewed by you?
That's
I
in the
don't know,
process. That's in the process. It's-
What?
It's part of the orientation process that they meet with the medical director.
They do meet with the medical
Yes,
director?
sir.
Yeah, that was the question that I had, because that, I think that is very important.
And he is involved in our quality assurance program, and if we do have chart review or we have issues that potentially,
Yeah.
are an issue with how we treat folks, the medical director is immediately contacted.
Judge, this is a unique opportunity because Dr. Yarba works in the ER at the Georgetown Hospital, who works every day with the staff of EMS. This is a unique situation, and I don't think we'll find anyone more qualified to do this, and I would make the motion for his approval.
Second.
Who seconded? Mr. Huff?
And I, just to echo, the medical director does have a key role
Yes,
with the quality of the service, from when we change protocols or we establish protocols for patient care and quality, to the very hands-on experience. And I can say that the ambulance service is fortunate to have an opportunity to work with a physician of this quality.
Any further discussion? All in favor? You got it.
That'll
Thank
be
you.
effective January 1st.
Unanimous. That's effective January 1, is that right?
Yes.
Glenn had an update on a new hire for his office.
Let me explain this request to the court. Back in 2008, had a long-time employee retire. One of my many associates that, helped her run our office as smoothly as it can be. And at the time she retired, I chose not to fill that position for a couple of reasons. I know we were in a tough economic time, and county wanted to put a freeze, and did put a freeze on hirings and salaries, and I wanted to cooperate as much as possible, so I did not ask that position be filled at that time. You were kind enough to allow me to have someone come in as part-time for about 18 months or so, and since that period, that position's gone unfilled. What has occurred, and I guess more so this year than any before, our caseload has increased so rapidly in the district court, not only in district court for criminal and traffic matters, but for all other responsibilities that we have. And then we've seen over the last 10 or 12 years in particular, an uptick in the number of cases we file for disability determinations. And I can remember when I first started many years ago, there were probably 4 or 5, and now we participate in, if not do between 40 and 50. So I've got 2 staff members and a third one that kind of take care of a lot of the district court matters, but with the additional caseload that we're seeing in the regular district traffic and criminal, plus the increase over the last 4 or 5 years in these disabilities, I've just been caught, I guess shorthanded would be a good term. So I'm asking the court to allow me to hire someone. We've had a vacancy in my child support division since back in June, and that money was already established, so that there should be money in my budget left to pay a person hired from the first part of January, first of the year through the end of the fiscal year. But I would be asking that that position be filled during the next budget year as well. So it is someone who I plan on taking the disability determinations and assigning that to the new employee, plus cross-training the new employee to do district court work from the diversion programs and various things we have to do there. I'll be happy to answer any questions, but it's just gotten to a point now where I just can't do without that employee.
Well, I can back you up tremendously on your statements because the courts are just getting overburdened, and I know the situation that your office is in. And I'm glad to make the motion that Glenn be given the help he needs.
Is there a second, David? Any questions?
This is an attorney position, I'm taking.
No, it's staff member. Staff, yes.
Any other questions? All in favor? Okay, it's
Yeah.
unanimous.
I thank the court. You've always been good to me, and I think this will help streamline some things that we've had difficulties in the last couple of years in meeting deadlines on. I appreciate it.
Next item on the agenda is about the museum repairs that we've been making. We have substantial completion on the electrical and also on the heating and air. It came in under budget of what we had budgeted. However, there's a lot of repairs that need to be done. The plaster is being repaired right now, but we need to move forward with it. The building needs to be cleaned where all the work has been done. That's in almost $3,000. The floor where they took the radiators out is busted and repairs need to be there. The cleaning people said it would be cheaper to buy curtains or shades or new blinds than to try to clean them. The painting needs to be redone. And what I would like to ask the court to do, and we'll still be under budget, is to give the museum board $25,000 to make the necessary repairs that will be forthcoming. And they can do this work rather than us coming through here. And we budgeted $300,000 for this work, and even at $25,000 will still be under the amount.
And since it's different services, it doesn't have to be bid out, correct?
No, if they do it, it doesn't have to be bid out, and it doesn't have to be bid out anyway,
Okay.
because, you know, the time you accumulate all of it.
Right.
The only one that would have had to be bid out, and I don't know, because we haven't got a final, patching all that busted plaster and painting and sealing where the roof had leaked over the years. JR and them fixed it. It's not leaking now. The wall was stained, and some of that work has been done. But there's a lot, if you go up there, it's gonna look great, but it don't look great right now. And anyway, I would like permission to write them a check and let them do the work. And that's where we stand. And we will be under budget. Bill's at your motion. David second. Any questions? All in favor? Okay, it's unanimous. Thank you. And then the electrical inspection agreements. What this is, there are 4 electrical inspectors that work at Toyota, and they've been working there, and they need to renew their agreement with Toyota through the state, and that's the only place they work. Whenever they move a machine or whatever, it has to be done by a certified electrical inspector. And the four names are Tracy Bethel, Tom Bertram, Eric Cook, and Jim Dartley. And that's the only place they'll work. They're doing it now, been doing it for, I guess, years. But they have to be certified. And we were provided a form that needs to be completed, and I'll get Glenn to go from there with it.
You know, this is a contract, how it's entitled between the fiscal court and each one of the individuals just mentioned. It is done pursuant to KRS 227. We have the power to regulate the installation and operation of all the electrical wiring appliances, et cetera, in and about buildings and on public property. Fiscal court pursuant to that chapter has the authority to at least appoint these individuals to conduct or provide electrical inspection services in Scott County. I had the form, Judge Leslie was kind enough to supply that to me, and it made some statement where they were going to, I think, be employees of the county. Well, they're not really employees of ours. What we're doing is authorizing them to provide electrical inspection services in Scott County. And that electrical inspection or inspector will be a certified inspector and will have such authority per law. They have to sign this agreement under oath that those things are in fact true. But that's basically what the contract says, signed by Judge Lusby with court approval, and then each one of the parties named would be signing as well.
Need a motion to enter into a contract with these four individuals that we named to provide electrical services.
Motion.
Livingston, Mr. Tackett.
These are employees of Toyota?
No,
or-
I don't think they're,
or are
they work
contracted?
at Toyota.
They're contracted with Toyota, or, I'm not sure I understand.
Well, you've asked a question. I was asked that same question, but they've been doing it for years. And I think, I don't know.
But they're not county employees?
They're not
they're
county
not county
employees, doing work in Scott County. And any electrical inspector has to be a contract. If we hired somebody to help Don, we would have to authorize them to do that. And that's,
Who pays them? We don't know that.
Toyota pays for them.
Okay, so they get like an inspection fee rather than an
I
employee of Toyota?
don't,
and all
they
that?
don't come through us, so I don't know. And we don't have the time nor the ability. What I was told, and I talked to Kim Minke, they work on Saturdays, work at night, depending on what needs to be done. And that's why they have four of them. Any further questions? All in favor? Okay, it's unanimous. We will have the swearing in for all elected officials on December the 28th at 2 o'clock here at the office. And one of the things, if you want to be sworn in, we swear in by groups. However, if somebody wants to be sworn in individually with their family or whatever, we'll do that. But 28th, right here in the courtroom, so. Perfect.
I'll be out of town, so I'm gonna have to come see
Come
you
in
with
early.
somebody.
Okay.
Anybody fight a duel?
Now be careful what you say on that. That's all the items that I have on the agenda. Does anyone have anything to bring up? Mr. Hughes? Glenn?
It is a Sunday.
That's a Sunday, 2 o'clock,
Okay.
yeah.
One thing, Judge, being that the road has, got the first part down at Great Crosses and whatnot, I think this court, being it's under this court, should consider naming that road. We need to consider that, we've only got one meeting left.
Okay, well, we considered, I hadn't, and it needs a name.
Those that haven't been out there need to go check it out, it is.
Well, it's
And
not-
some people are using it even though they're not
Well,
supposed to.
we've got to block it off, yeah. But,
Super nice.
yeah, I don't have any problem with that, but I would like, that can, we gotta be careful what we name, you know. Make somebody happy and somebody mad, if you name it after somebody.
Who normally names the roads in the county? I mean, are
The
we?
subdivider, usually, and that's right, Jared.
I thought Mike
the-
Wright used to do it.
What?
Mike Wright did it on some of them.
Well,
No, that was box numbers.
well, he
Well,
did
he
too,
was
like,
to
some
you
extent,
couldn't,
not always.
you couldn't have two roads with the same name.
Yeah.
And you change Oxford Pike to Oxford Village Road or something. But those things were not quite as complicated. If you start naming a road after somebody or these types of things, you know, that's why I say it's, Tom, when you were mayor, you did a good thing. You had a contest.
Yeah.
And it worked out good.
Cherry Blossom Way, for when it was under construction, was just called the Road to Toyota. Or the mud path out there when it was under construction. So, we held a contest open to, children 16, youth 16 and under, and asked them to submit their recommendation for the name, and we also asked them to give an explanation of why that name would be appropriate. What's funny is, given that Martha Lane Collins was governor at the time, we had a lot of entries that were for Martha's Lane. Of course, we had that. But a young man selected the name Cherry Blossom Way for great reason. He said that cherry blossoms symbolize spring and a new beginning, and that this plant represented a new economic beginning for the community. So, but that was kind of a fun way to name it.
But it's not as simple, because it's gonna be there unless they do like they did with Daniel Boone Parkway. So,
I like that.
but, yeah, we can talk about it, Chuck.
Yeah, we need to.
It's not something you wanna take lightly. David, you have anything?
No, sir.
When you're through in the courthouse after the 2 o'clock ceremonies on the 28th, step across the street. We're gonna do a similar thing at 3 o'clock with a kind of a short program, and
Okay.
we'll be doing some swearing in over there as well.
John T?
Just Merry Christmas.
I have instructed JR to put a dumpster outside the magistrate's window. That's off the record. But this, with losing 5 members of the court, is pretty significant and gonna be touchy. And I've asked Jared if he would, while we're all here together, to get a picture. I'd like to have one for my book and maybe for yours. And if we get down here in front and take a picture of the court, I would appreciate that. But being no further business, we stand adjourned. I didn't ask you, you had. I know, Steve.
Thank you.
Oh,